everyone. That's the second day and the last day. We have very exciting panels today as well, so we hope you will be staying until the end. Before we start and keep up with Julia and Ashley, I just wanted to give Ashley his present. That's all my fault, okay, because I had too many bags and not enough hands yesterday night. But in a way that's better like this, because at least everyone will remember it, okay? Because we are recording, so... Thank you, Ashley.
Great, well, thank you for that introduction, and thank you to Google and the other sponsors for that lovely dinner last night. I've done quite a bit of litigation against Google recently, so I couldn't help feeling a little bit guilty as I was enjoying my chicken with a nice red wine. But I'm a partner at Olswang. I specialise in media and internet disputes, and I typically act for internet intermediaries, actually, but I occasionally do some work for deserving claimants where conflicts allow. My introduction is about right to be forgotten section, but actually I think what I want to talk about is slightly broader than the right to be forgotten, because what the Keynote decision has done is far broader than simply about this right to be forgotten. I don't know if everybody remembers that day when the Keynote decision hit us all. I was in a conference in Palo Alto at the Legal Frontiers and Digital Media Conference, and there was just astonishment in the room of American First Amendment lawyers of what on earth is this all about? How could Europe tell us to take this stuff down? And we started digesting it, and the ICO got involved, and it all got slightly crazy, and the media got into a big frenzy about it. But what that has done is opened up the eyes of loads of lawyers across Europe into the power of the Data Protection Directive, and in particular actually in the UK, as to how tools that have been around since 2000 can be used to protect reputation in a far more effective way actually than the laws of libel and privacy. And that's leading to some tensions. We heard yesterday about how copyright law leads to some tensions between economics rights holders and ISPs as to what's proportionate to protect those economic interests. In the sphere of reputation, it's the same. We're concerned about the right of individuals to privacy and reputation, but that's got to be balanced against the right to freedom of expression and the ability of internet companies like Google, Microsoft, Twitter, Facebook to innovate without being bogged down by regulation and constant trivial requests about something that happened 10 years ago. So before I sort of delve into a couple of the more detailed issues, I want to sort of step back and think about what has happened over the last 15 years since the e-commerce directive and the data protection directive were drafted. It's a dramatically different environment. We're now in an environment where newspaper sales are dwindling. There's a move to online news. We all get our news now through Twitter or through Facebook. We are getting it through mobile, tablet. And whilst Google search and Bing search is very important, of course we're now also finding alternative ways to get information through social media, through apps. Internet service provider is a phrase that's really got on my wick for years because it's so narrow and so misused. What people meant by ISPs when they started coming up with this phrase in 2000 is internet access providers generally, or hosting providers. And yet now we've got so many different players in the market who could be described as internet service providers. And I know the Commission are looking at this. It's about time we grapple with all the different players in this space and try to come up with a definition and work out actually where people stand in the food chain. I was in the House of Lords with a group of technology companies around trying to explain to the government about Section 5 of the Defamation Act, which is a new defence which came in to try to give internet intermediaries a defence to defamation and put the complainant in touch with the author and take the intermediary out of the picture. And I was trying to explain to a member of the House of Lords, who was well into his 60s and probably had never used Google, that this wasn't really going to work, that their detailed procedure for identifying anonymous users on the internet was not going to work. Because people who cause problems on the internet by harassment or things, they don't come forward and say, here's my name and address, please sue me. And the House of Lords seemed to think that was a suitable solution to this issue. And Section 5 of the Defamation Act is barely used in practice, and yet there were hours and hours wasted on it. You know, this is a very, very difficult area to regulate on, particularly when your regulators don't quite understand the media. But I tried to explain this, and the House of Lords member said to me, that's all very interesting, Mr. Hurst, but Mumsnet, what can I do to help you? And Mumsnet were in the room, who were what he thought were an internet publisher on behalf of mums interested in daily issues. What he hadn't realised was that Mumsnet is an intermediary service provider. They're a web platform that takes in user-generated content. They were facing the same issues as TripAdvisor, as Google. So we can't have a one-fits-all approach to this. What you do that regulates for Google might also impact on those new upcoming startups that are using user-generated content, having discussion forums, hosting platforms. And of course now, all of these companies, Google, Twitter, Facebook, they're no longer in California, they're over here in Europe. You know, the regulators know that, they know that, we've got nice shiny offices, we've got people here, they're open, they're engaging, and that has changed the environment, and that's leading to further legal developments. You know, we've seen the raising of the bar for libel in the UK. No longer really the libel capital of the world because it's harder to sue for libel. And therefore, claimant lawyers are looking for alternative ways to bring reputation claims. Since the second decision, privacy is the big new weapon. I'll come on to that. But we also heard yesterday how harassment is also a potential weapon. Can internet intermediaries be liable for harassment? Something which is associated with criminal law. The House are uneasy about that. But you can see how an argument can be constructed. And of course we've got an increase in blocking injunctions, but I came up with a phrase about 3 years ago saying watch out for the micro-blocking injunction. You know, at the time it was all about music piracy, wide-scale blocking of IP addresses and websites. Now we're starting to see the blocking of particular videos, particular photographs, particular blocks of text. People are going to court and asking for creative technical remedies, and that's only going to increase. And finally, the European Commission has said, well, the e-commerce directive, Article 12 to 15, maybe we need to take a look at that. And I don't know whether you've seen their leaked consultation document, but it's extremely broad, and it's going to be very interesting to see where they go with that. I recommend you read Sophie's article on Inform, on the Inform blog that was published a couple of days ago. That's released next week. And what does this changing environment mean for reputation management services? People who are defamed on the internet or harassed on the internet, they're no longer interested in compensation. It's not like Elton John in the 80s where he wants to have 2 years of litigation for £1 million in damages. People just want this stuff taken down. You know, those that are serious about it, have been damaged by it, they just want it taken down. Most of the time, they only want their legal costs back. And so, we were in this environment where internet service providers were worried about being liable for damages. That's why they don't proactively monitor and go out looking for this stuff, because they're scared of being liable for damages. And yet the claimants don't care about damages. They just want this stuff taken down. And they're looking for other remedies. Because the internet is such a difficult medium with which to engage reputationally, the only way to do it is fighting it with content. Using SEO companies, reputation management companies, to drive positive content up so that the negative content goes down. Often that's the better route than trying to resort to litigation tactics to get stuff taken down. But this is all leading to a really, really complex environment for internet intermediaries. And they've got a lot on their plate right now. Google, of course, are front and centre of it. And if they've not got enough issues to deal with in terms of competition regulation, they're having to deal with multiple requests for right to be forgotten, data privacy requests. We've got regulators all over Europe stepping in and wanting compliance with their laws. So some kind of simplicity at some point is going to be needed. One thing to assure is that the Data Protection Directive and the E-commerce Directive are out of date. They were drafted for a different time. We've got differences between how those directives and how the defences apply to data privacy as to how they apply to libel and privacy in the Article 8 sense. And isn't it crazy, the suggestion that intermediary service providers can rely on Article 14 or 13 of the E-commerce Directive in respect of an Article 8 privacy claim, but if that frame is framed in terms of the data protection legislation, according to the E-commerce Directive, the Data Privacy Directive, the E-commerce Directive, I'll come on to show, matters relating to data protection are excluded. That cannot have been the intention of the legislators back in 2000. And I think what this means is data privacy laws are open to abuse, and I see it regularly. I see it on both sides of the fence. People wanting to get stuff taken down which shouldn't be taken down. It's legitimate, it's not out of date, it's not irrelevant, it's in the public interest. And on the other side, where these internet companies are getting a lot of spurious complaints from both lawyers and non-lawyers. The threshold needs to rise a little bit. So, how long have I got? No. 10 minutes. Okay, so it's really important when analysing this area, I think, to differentiate between liability for damages and injunctions. We heard lots yesterday about blocking injunctions in the IP space, but very rarely do you see cases brought for damages against intermediary service provider. I still don't know, other than Godfrey and Dimon Internet back in 1996, of a case where an intermediary service provider has been held liable for damages for not taking something down quick enough. Google nearly got there in the Temmie's Google case and got away with murder. But they don't do it. And why is that the case? And that's because the intermediary service providers do actually have quite a robust set of defences in the E-commerce Directive. But those defences, Article 12, 13, 14 of the E-commerce Directive, they're defences to damages claims. Excluded both from the E-commerce Directive and the Data Protection Directive is the ability to get an injunction. And of course, that's why we've seen blocking injunctions, and we're starting to see injunctions in the data privacy arena. And really, what I go on to say is that's what it should be about. It should not be about when our internet intermediary is liable for damages for something they didn't post. It should be when is it necessary, proportionate, reasonable to force those providers to get involved in the process and take it down. So if you look at what's happened in the defamation arena, and this doesn't apply to data privacy, we have this pre-requirement in the UK, I think this applies to some of the European countries, of a common law publisher. It's a very arcane concept in English defamation law, that in order to be even within the realm of being liable for damages for defamation, you've got to have some kind of responsibility for publication, some kind of mental engagement in the publication process. And of course, whether you're an internet access provider, a host, a search engine, a website operator that has a forum, you don't get involved in that process at the point of publication. But at what point, when an intermediary is notified of defamatory content, of private content, or harassing content, and it decides not to take it down, at what point is it culpable? Now, English law have got to this ridiculous position that there comes a point, at some point after notification, where they're a common law publisher. They're engaged in the mental element of publication. But only from that point do you start to consider, well, how long have they now got to take it down? And the E-commerce Directive said you've got to act expeditiously. How long is that? In time using Google, it was 5 weeks was fine. If I'm being accused of being a paedophile, completely unnecessary, I want it taken down quicker than 5 weeks. But of course there's no guidance, this is all a matter of feel. What is reasonable in one case against a company with armies of paralegals dealing with hundreds of complaints all over the world is very different from a small provider that only maybe gets 10 complaints a year but doesn't have a lawyer. But this is just a quagmire of uncertainty for ISPs. We shouldn't have to worry about at what point they become liable for damages. What they really want to do is, for the hard cases, is to send this off to a regulator like the ICO to make a quick adjudication, take it off their hands. I'll come back to that. So why are people using damages, data protection rather than libel? Well, they don't have this requirement to demonstrate that you're a common law publisher. No mental element is required. Is it personal data? Very broad. Is the data being processed? Kosteka says that publishing material online is processing. And who is the data controller? Who determines the purposes to which the data is being processed? Well, that is a really difficult question, depending on what is happening. We have to look at what's happening with a particular piece of data at that particular time. If it's being taken by Google from a platform, being put into a big bucket and used to serve advertising, they're determining the purposes for which that data is being used. But are they determining the purposes when it's posted in the first place on blogger.com? According to the CJEU, they are determining the purposes for when it appears in the search results, because they determine the algorithm. And that's what it says, they're data controlled. That's why we've got the Google Spain decision. And bear in mind, this is law that's been around since 2000. Actually, when you think about it, some of it isn't that surprising. But is it right? And look at the consequences of it. So the Data Protection Act, like all the others across Europe, provide for damages and they provide for an injunction. And so that's quite a bit more simple, isn't it, than worrying about what words mean, or whether there's qualified privilege, or is something an honest opinion or fair comment, or that sort of quagmire of defamation law that I've been worried about for the last 10 years. But surprisingly, all the defences available in the E-commerce Directive don't appear to be available for these claims. So recital 14 of the E-commerce Directive very clearly says that matters relating to personal data are outside the scope. Now, the big other aspect of the E-commerce Directive and hugely important protection, which supposedly falls outside of data privacy claims, is Article 15, like the no general monitoring provision. So at least in theory, according to the strict wording of these two directives, you could go to court and get an injunction against a service provider without needing to worry about what you're asking for imposes a general monitoring obligation. Now clearly, that's not going to work. The court is not going to grant an injunction which requires Google, for example, to scour its servers of the internet to find content which is appearing in its search results. But the real reason, apart from if they can balance those two directives out, is the principle which Mr. Justice Arnold talked about yesterday. It's about necessity, proportionality, and effectiveness, dissuasiveness. I'll come on to that. But we're in a weird territory at the moment, because that Article 15, of course it should apply to data privacy claims, which only demonstrates that nobody was thinking about this back in 2000. So that's the kind of little bit of a mess that needs to be cleaned up between those two directives. But what's happened in terms of the right to be forgotten? Well, I'm going to leave that to the panel. In the UK, we've had a couple of very interesting cases in Heglin and Moseley. Now, Heglin, I think, is an interesting case in demonstrating exactly what I've just been talking about. Here is a guy who's a very reputable former Morgan Stanley banker, international businessman, family man, suddenly accused on over 5,000 websites of being a murderer, paedophile, you name it. A load of nonsense, really. It was a block of text that was being used, a computer software system was being used to repost this stuff on multiple websites with an open forum box. And so it was no good playing that game of whack-a-mole, because every time you got one website taken down, another would appear in the Google search results, and another website would appear. This thing was continuing. He needed something more. What was the impact? Did people believe he was a murderer and paedophile? Of course not. People that knew him especially didn't. But it was that whole sense of, do you know what, there's something out there. And he would go to business meetings and be confronted with this stuff. I just Googled your name and this stuff, come on, we know what's going on there. This is very distressing stuff. He could have brought his claim, a defamation, harassment, Article 8 breach of privacy, or data privacy. And he could have sought damages. But he didn't. He just sought, really, one injunction under data privacy legislation for some kind of remedy from Google to help sort this out, rather than wait 3 weeks, 4 weeks for every takedown request. So that was a deserving case, but how do you balance that? When Google has to consider, well, hold on a second, you're asking for something, to do something, and yes, it's an exceptional case, but what if everybody can suddenly ask for that remedy? Everybody that suddenly has an article they don't like in a press report 2 years ago, suddenly want that to be blocked on a regular basis. And so that's why Article 15 is so important. And that when it comes to a judge deciding what's proportional here, he needs to be able to say, well, no, there cannot be a requirement for general monitoring of these systems. But there may be an occasional case where a deserving person gets over the line for slightly more exceptional remedy. We've just seen, Mosley, by the way, that case settled. Max Mosley was asking for very similar things over pictures of whatever he did in that dungeon. But that settled as well, so we're not going to clear this up for a while. The ICO have just given their first enforcement notice. I understand they've now dealt with over 400 cases on right to be forgotten. And the vast majority of that is behind the scenes. If the ICO don't like what they see, they tell Google, we will take it down. There is a process going on here, 400, which actually is achieving results fairly quickly. Google probably fairly happy because they make an initial call, and then they step out of it on the hard cases, and there are hard cases, and the ICO step in. And that's a pretty good result. That's a lot better than spending £20,000 on a court injunction, and then going to appeal, and appeal, and appeal. So how about we think about some similar process for that? Given the fact that this is all about reputation, why don't we start thinking about a similar process for libel and privacy claims? We've got Google's Dutch lawyer in the room who could tell us a bit about the Dutch cases, which are very interesting, slightly more media friendly. In France, we can hear about how they're less friendly to Google, and in my view, extremely ambitious in how important French law is in the global context. But we should wait to see the justification for their views. And here are the other burning issues, which I'm not going to answer. Does Costeca apply to Google.com? Does Google.com accessed in France or accessed from the US? Should member states order blocking of material outside its own jurisdiction? Should non-EU citizens be able to rely on right to be forgotten if their personal data has been processed in the EU? Should Google notify publishers in advance of de-indexing? Should publishers have a right to get involved in this process? When they think it's in the public interest, should they get involved and have a right to appeal to the ICO? Should Google be able to post some results may have been removed under data protection law in Europe? I mean, they might as well have a sign saying, go and have a look on Google.com, there's some interesting stuff. But is there a better solution than to make online intermediaries the decision makers at all? And that's my central premise. That these laws are completely outdated. This area is a total mess. You know, I spent years trying to understand all this, but it's amazing how many specialists in this area do not understand this area. You have to understand data protection law, privacy law, libel, e-commerce directive, and you've got how does it fit in with competition law? So someone needs to step in here. But I think read Arnold's judgment in the Cartier case, and that gives a blueprint for how judges should approach these cases. Some broad principles about balancing rights with some guidance to make sure it's effective, proportionate and persuasive. There's a pretty good methodology in that case, and we're seeing that in other cases as well. Is it about time we had immunity for damages for internet intermediaries? I think so. I think we need to start working out a way of focusing on making sure deserving claimants can get stuff taken down, but make sure that internet intermediaries are encouraged to innovate, to develop new technical tools to find this damaging stuff that frankly they don't want on their servers. Twitter don't want to have suppression stuff on their platform. Facebook don't want it. Google don't want to have defamatory links coming up on its index unless it's in the public interest. But they're afraid of getting involved in this because they're going to be able to open themselves up to scrutiny. So, yeah, someone needs to take a look and let's allow tech companies to innovate. So those that do need a solution can have one without spending vast amounts of money.